first of all, it's not referred to as stay put in the actual statutes. It's referred to as pendant placement, but somehow stay put is a lot easier to understand, and so stay put stuck. So the idea is if you have an IEP and it guarantees your disabled child certain services, it would be important to not have there be interruption in the child's educational program if you got to the point further on down the line where there was a disagreement about what services the district should offer. So the idea drafters in their infinite wisdom decided that if there was a disagreement, let's say at the IEP meeting, and the parent didn't want to put the child in a change of placement, instead wanted to have a hearing, a due process hearing about the appropriateness of the district's offer. During the pendency of the due process hearing, the student would remain in the last agreed upon and implemented placement. And so that gives you a certain degree of protection against arbitrary changes that are detrimental to your child, and instead allows a administrative law judge to hear the evidence and make a decision about what the placement should be. So that's one thing, that's the overarching concept about stay put. It preserves the status quo. When you get into specific situations about how it works, it gets more interesting. What happens when you invoke stay put at an IEP meeting is it's supposed to automatically prohibit the district from changing the placement, and it's supposed to be kind of an automatic injunction that you can secure without having to show damages or irreparable harm. But in the last 10 years, we've seen more and more districts saying they wouldn't honor stay put unless you file for due process. So if you found that your district wanted to change your child's placement and you didn't agree, you would be able to only invoke stay put if you filed for due process hearing. And then all during that hearing and after the hearing, during the time the hearing officer was deciding, and then upon appeal, if you disagreed with the decision of the hearing officer, you would have stay put. So you can see you'd be able to potentially perpetuate a disputed placement for a long time. So let's talk about some specific situations. That'll bring us to our question, which I think is a stay put question from the way it's written. I told you that the placement had to be had to be the last agreed upon and implemented placement. If it's a placement under discussion and the parent has never consented to the IEP, that wouldn't be eligible for stay put. It can also apply to a settlement agreement, and in fact, in a lot of the settlement agreements that we draft, there's a clause that will actually spell out what the stay put is, so that if you get into a disagreement, you don't have to litigate what the stay put is, because you could see that might be a ripe area for disagreement. So the policy is one of preventing unilateral exclusion, and then the question is, to what does it apply? And in California, it applies to personnel, location, facilities, and not just the classroom. So that means that it could be a particular type of service you were having, and it could even be a person, but only if that person's name was written in an IEP. And in all the years I've been practicing, I think I had one case where the district aide was named in the IEP, and when the district tried to remove that person, the parent was actually able to prevent that by invoking stay put. But that's not likely to happen. So another exception to stay put is if the placement closes or no longer exists. There's not a stay put in that situation. We talked a little bit about moving out of the district last week, and if you move out of the district and you disagree with the new offered placement that the new district proposes after 30 days, you can invoke stay put as to the old placement. What becomes interesting, though, is how do they implement stay put if you're in Weed, California, and your old IEP was from San Diego, California, and you were attending a non-public school. But we're not going to get that microscopic for today, except for just to point out it's a question and it's a problem area. Now, I was thinking until very recently, I had been told that if you invoke stay put at the end of the school year, your child would have to stay in the class level that he was in while the issue was being disputed. But I found case law when I was researching this more recently that says that even if you invoke stay put, the student would be expected to move up to the next grade in the same placement. So those are some exceptions. In the old days, when districts would routinely agree to stay put and you didn't have to file for due process, we did some outrageous things. So, for example, we had a Los Angeles Unified kid that had a 40-hour-a-week ABA program. District proposed a change of placement, probably to a district aide. We invoked stay put at the IEP meeting, and when I came up for air 4 years later, the kid was still in his 40-hour program. I don't expect to see that kind of thing anymore, but it's fun to tell you all some, historical stuff just for, entertainment purposes or something like that. Just because we have to do this doesn't mean we can't have a little fun occasionally. Anyway,
Love it.
In terms of practice, as I've said, you invoke stay put at the IEP meeting, and if the district won't honor it, then you have to file for due process. And I can tell one more war story. I made a mistake in a settlement agreement, and the agreement was supposed to say, kid got 10 hours a week of ABA after school, and if a disagreement arose after the first year, it would revert to 5 hours a week. But instead, during the settlement, what we wrote in was 5 hours a week of ABA. No, it was 5 hours of ABA hours with no time frame reference. And this was because we were going through multiple drafts in the IEP meeting, and we all got tired at 6 o'clock at night, which is a lesson in and of itself. But when the district at the year point predictably said, okay, we don't agree about the 10 hours anymore, now you only get 5 hours, they said it meant we only got 5 hours total. So we had to litigate that issue via a stay put motion, and ultimately we did win. But it should serve the purpose of illustrating for you that if a district has wiggle room in terms of stay put, they're probably going to implement it. And if you get interested in stay put, you can go on the OAH website in California and read some stay put cases. I did that yesterday, and I mentioned that stay put is in place on appeal. Now, when you graduate from school, whether it's with a regular diploma or sort of a special diploma, you cannot stay put the placement anymore. So that's another thing about stay put, is it doesn't continue in perpetuity. It lasts only as long as you're eligible for IDEA services. So now our listener writes in and asks a question that I'm going to try to answer. It's a little fact dependent, depending on whether I'm interpreting his or her characterization of the facts correctly. But let's see. So it says, my school district offered me a placement for my son that was in a class with a third, fourth grade split. So my first question was, well, where was he before? Because all we've got now is an offer, not an implementation. And was this in fact a general ed class? It sounds like it. Is this a student with an IEP? We're going to assume so for purposes of answering the question. My son is in third grade, but the team thought this would be good for him because he gets bored. 1 month into the school year, the enrollment was up, which I think means increased, so they shuffled the classes and his class became an all fourth grade class. He was moved to another teacher for third grade. So she goes on to say, I argued that his placement was supposed to be third, fourth, and they said that placement no longer existed. Well, first question is, does the question properly convey that he was in the third, fourth for a little while, in which case he probably could invoke stay put, but if the placement no longer exists, then that's an exception to the stay put rule. I argue that his placement was supposed to be third, fourth, and they said the placement no longer existed. Now I just found out they're going to shuffle the classes again and create a new third, fourth class, but they're not offering it to my son. I'm not sure whether I want to put him in third with a new teacher in such a short time, but I would love to know what my rights are. My answer to that question is I'd love to know what your rights are too. It's a very complicated question to me, because if he was in a third, fourth split and it was actually implemented, I think there'd be an argument that that is the stay put placement. But my guess is you'd end up litigating that because the district seems to have a different point of view. Now, I forgot to mention one other thing about stay put, and that is there are instances in which the district is justified in not adhering to stay put. And one is if they think a student is dangerous, they can go into court and get an injunction to prevent the student from staying in the class. The other is if the student used a weapon at school or possessed and sold drugs at school, the stay put gets changed and they can put you in a 45-day interim placement while they're figuring out what to do with you.